Good afternoon, everyone. Thank you for coming to the Nest Egg Builder. We are so very excited to have Bill Gross with us. He is a longtime real estate investor and agent, and he specializes in probate, and he's going to explain what probate is. At one time, before we got into the situation of COVID, he would go down to the courthouse and whoever wanted to go learn about probate could meet him there, and he would explain the whole process of what was going on. And then if you wanted to get into probate, well, he'll explain all of that to you. So Bill, welcome, welcome, welcome. We are so excited to have you today.
Thank you. Thank you so much. Thank you. I've known Peggy for a while, back pre-COVID. I think that's a new defining thing, by the way. If you know somebody, during COVID, it means you never met them or talked to them. But I knew Peggy pre-COVID. We actually had lunch together a few times in person and spoke in person, probably hugged in person. Imagine that, a real human interaction. But thank you. And yeah, my goal here today, I like to help you, and I like this to be interactive. I'm not selling anything. I don't have a coaching program. I don't have any data, but I want to sell you on the dream that you can increase your income and or build your wealth through real estate investing. And I also would share with you the tactic of finding an area that you specialize in and getting deep in that and creating expertise. And that will give you the confidence either to make money as income if it's your business, or the confidence to make investments if that's your goal to build wealth. Excuse me 1 second. I chose probate because, let me back up. When I went into this, I sat down with one of my business coaches, and knowing I needed to create a niche for my primary business, which is real estate sales. I'm a real estate broker in Los Angeles. And what he said was you have to have a niche and be considered an expert in an area for people to consider working with you. And so I had known about probate real estate as a marketing technique for real estate agents, but I didn't really go deep in it. But it seemed to fit for me. My father had been an attorney. I had a lot of clients who were attorneys. I like wearing Brooks Brothers suits and ties. I love going to court. It was kind of fun for me. That's not for everybody. I get that. But so I carved out the niche, and I created a marketing plan where I went to court every day, as Peggy said. I not only went and met attorneys there, investors, saw the proceedings, learned. I also set up meetings there. I would invite investors to come and learn about the process. So it was a great lead generation process. I did that for a year before COVID closed down the courts. Since then, I had to move my business online, so I host a program every Tuesday, actually at 3 o'clock today. I'm going to jump up here at 2:50 or so to launch it. realestateinvestingzoom.com. I've had Peggy on and share what she does as far as her investment program. I've actually referred a client to her, a couple maybe. I also host another program on Thursdays, probateweekly.com. That's Thursdays at 4 o'clock. And so I really believe in giving information, giving education, and kind of fertilizing the soil before I expect the harvest. That's kind of how my approach to business is. So I'm open to answering any questions you guys have today at all about real estate or investing or probate. I will just share a little bit about the concept of probate real estate and what it might mean for an investor. One of the common themes of our market today, one of the common overriding principles or facts, is the lack of inventory. Have you guys heard of that concept? There's just not enough houses for sale, right? So that means if you're a real estate agent and you're showing a buyer property, there's few to choose from. If you're a buyer, there's few to choose from. If you're a seller, you don't have a lot of competition or as much competition. But as an investor, it means there's less opportunities for you, or you're going to pursue opportunities at a lower rate of return than you might normally. And so what probate does is it maybe adds a few properties to the inventory at the edges that might be of interest to you. And so as you look at property, what I would say is the best thing that you should take away from this is that if you find a property that you would love to make an offer on or love to buy, but for the fact that it says probate, you know what that means, I'll cover some of the main concepts here, but feel free to reach out to me if I can help, because it is a deep process. But I would say overall that investors make the most money when they solve somebody else's problem. Meaning, somebody has a property they have to sell. One problem could be they need closing right away. One problem could mean they need some of the cash right away. One problem could mean the property has a problem and needs to be fixed up or value added. And they don't want to do that. So a lot of different game plans, but almost all property at a level, there's a problem that somebody has and they want you to solve it somehow. If you solve it, then you get the business. Or as a retail investor, meaning an investor who buys a property that's already fixed, the professional has the inventory and they want to bring it to market, and then the retail buyer pays the price that they get for it. So probate, what happens is some properties have title issues where somebody owned the property and then somebody else is obtaining it. So it could be, parents pass away, grandparents pass away. There's a lot of different factors going into it. It could be conservatorships or guardianships where the person who owns the property doesn't have the mental or legal capacity to transfer the property. Or it can be a combination of all those things. I had a case where it was a probate, and then it was a conservatorship, and they moved it into a trust, and there was some trust litigation issues. So probate to me is a broad topic for title issues relating to succession of property. Somebody owned it, and then somebody else owned it and wants to sell it to somebody else. And as an individual investor, I don't know necessarily that you would focus in on it. If you are interested, come to my probate weekly class, and I can direct you there, ask a question, and I can give you some resources. But I'd say most investors, what I find is I get regularly told, oh, my first house was a probate. Well, how'd that happen? We were looking, nothing was available. The realtor found this property, and it was a probate, and it was a long, drawn-out process, blah, 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 and we got the property. And I say, yeah, that maybe they could have shortcut the process, maybe you could have had, maybe you almost lost it, didn't know it. And so when you find those properties that you think are great deals, a neighbor, investor wants to sell to you, and there's a probate component to it, that's where a probate expert, an attorney, if you want to pay an attorney fees, or a probate real estate agent like myself can help you. Now, I'm not an attorney. I know a lot of attorneys. I would say I don't give legal advice, but I can give administrative and business advice to people in a probate situation, because I think I've seen more sales of property in LA County than any judge, attorney, or real estate agent. I went live for a year and a half and saw everyone that I could, and I still online go in and see some of them on a regular basis. I track them all, the database of every sale in LA County. So properties come on the market, and I think that they're agents, as real estate agents, bringing you properties. They might bring you probates that are one of two types. There are those that are what are called full authority, where court confirmation is not required, typically. In that case, it's like any other retail property. There's a different form. There's a different, slightly different process. But basically, it's the same unless there's a problem. And there, you want to make sure your agent checks and sees if there's any problems with the probate case. There was an auction on Sunday that I videoed on my YouTube channel, where I believe the buyers don't know, but not only did they buy it at an auction, pay what I would call a full retail price, but that sale has to go back to court for confirmation, is subject to somebody overbidding on it. And so they're going to sweat out that process. It could take a month or two minimum to get to court. If the attorney does his job properly, it could take longer if there's objections. So this is a case where you have to know what you're doing, knowing the case you're involved with, because if you might get involved where your money and deposits tied up for months at a time. That may not be a problem, it may be a problem. The other way you can buy a property is something where it's bought already in escrow but needs court confirmation. That's kind of one of the areas I specialize in, where I represent investors who go to court and buy those properties kind of at the last minute. And there you have to have a cash deposit of 10% of the overbid amount in a cashier's check format made out a certain way, and be willing to outbid the original buyer or anybody else who shows up. And there's no contingencies at that time. So you have to have done your research before you go to court. So that's in broad strokes, kind of the concept of probate. But I think I would like to leave you with, think of it as there's a title problem regarding to somebody who owned the property before the person who's in control today, and how to resolve that through is probate. And those problems get solved at probate court. Okay, so I did a lot of talking. Questions?
Well, I'll start off with a question because I always have questions. They're fun. First, I want to tell you all that you're all muted, so unmute yourself when you have a question. That's great. So what you said was there's the probate that needs court confirmation, and there's a probate that doesn't need court confirmation. And
Correct.
you said, did you say that most people don't need court confirmation?
About 90% do not need court confirmation.
Okay, but then there's a process of the overbid when you do need, and that's a certain dollar amount on the first bid and a different dollar amount on the, and how many bids is it before it just goes to you could bid $1?
Never that I've seen. So what happens is somebody bought the property. Like I went to an auction on Sunday. It's on my YouTube channel. Go to youtube.com/BillGrossEXP. You'll see my video of the auction. And there the property sold at auction, public auction, for $2.05 million. So that let's say $2 million just to make it easy for sake of discussion. So even though it says not may not be required, I happen to know a little bit about the case. I believe it will be required, because even if it's not required, all it takes is one of the family members to say, "Hey, I object. I don't think you got top dollar," and now it has to go to court confirmation. And I believe in this case there's 6 heirs. I believe there is one who's going to require it. So I have a little inside information, I think. But either way, it goes to court confirmation for $2 million. You have to be willing to pay more than that person by 5% plus $500. So if they bought it for $2 million, you have to be willing to pay $2.1 million and $500, and show up with court with 10% of that, which would be $210,050, and a cashier's check made out most commonly to the estate. So what happens is the court will say, okay, we're here to confirm the sale. Is there anybody who wants to overbid? And you raise your hand, and theoretically you've already been approved by the attorney that you have a cashier's check. And then the judge will say, well, who's willing to bid 5% plus 500 more? You raise your hand. And then seen every way imaginable for judges to go back and forth on raises, because they're not really auctioneers. I've seen the same judge do it different ways on the same court the same day. So there's no prescribed method. They'll want to go back and forth to get top dollar for the state. So they'll say 2.1, maybe 2.1500, 2.2, however they want to do it. They all have different methodologies. And then at some point, somebody drops off, and now you have a winner, either the original bidder now at a higher price point, or the overbidder has bought it and overbid them.
And did you say the people that did this at the auction had to pay cash for the whole thing, so they already brought in $2 million?
No.
Oh.
So what happened on Sunday was not a court confirmation auction. It was a retail auction. Rather than just list the property and get top dollar, there's a real estate company that kind of makes it sound like, oh, we're going to get an auction, we're going to get you top dollar for the price. And it's no different than any other process, but it looks fancy and there's a lot of excitement about it. And at that property, they're willing to bid $2,050,000, but still that only is a sale. And now the sale has been confirmed in court, most probably, and there'll be another auction on that property. Now, the truth is, I think they bid up enough where probably unlikely somebody will bid over them, but there's no way to know.
And then how long is it before the court confirmation would take place? So they
Great question. So theoretically, if you're the attorney or if the attorney's giving great service, he's filing on Monday, then confirm the sales price. Here's the buyer's name. Here's the dollar amount. He files on a Monday, and you get a hearing, or she, and you get a hearing date, most commonly 30 days when you file.
Oh.
However, most attorneys play around with the paper for 2 or 3 weeks, it seems like, and then they file it and it gets rejected sometimes. But I say 2 or 3 weeks, and then 3 days after that. And then before it goes to court confirmation, the court has an attorney who reviews the paperwork. Here's another thing that happens. Over half the sales get continued because the attorneys or their service doesn't fill out the paperwork properly.
Oh.
So now you're a buyer, you thought you bought the property, you put your deposit down. Oh, go back to your question. The original buyer at the court, at the sale, they showed up on Sunday with a cashier's check for $25,000, and they wrote a personal check for the balance of the deposit of 10%.
Okay, thank you. Anybody have any questions? Because I would think you all had questions.
There's a quiz at the end, so.
Yep, there's a quiz at the end. So one of the questions you might consider is how do you avoid probate?
Mhm.
Does anybody have that answer? Yes, Nika.
Trust. Put your real estate in a trust.
Okay. Any other
Is that the right
ideas?
answer?
Well, Bill's the expert, but I would say yes.
Well, only because I've interviewed so many attorneys, I would maybe modify your answer and say a trust is a tool in the toolbox to avoid probate. There's a number of different tools, a number of different types of trusts. So the answer that I would give you be a little more accurate, I'd say, is estate planning. Plan the estate so the property gets transferred the way you want, right? You don't necessarily need a trust if it's your spouse or somebody else on title. But I do think the trust works for most cases. Some people have there's other methods of holding title, but by far and away, the most common would be a living trust. But consult your estate planning attorney. And I will also say, I've had attorneys agree with me on this, that for 90% of people, even a bad trust is better than no trust. So I would say to anybody who owns property, whether it's your residence or investment over $167,000, there's a service trustandwills.com. In fact, I'll give you guys a link for a discount, for 10% discount.
Can you put that in the chat?
I will. That you should hold title and move it into to a living trust. And like I said, even though it's not ideal, and maybe you have some special legal requirements that need an attorney, most attorneys would agree with me, it's better to get it in something right away and then take more time if you need to in order to have something more refined.
And then I also understand if you put your property in an LLC, you don't have to go through either a trust or a probate because it's in the LLC. And it just goes, it's all the members who are in that LLC own the properties. And that's the title.
Well, the problem is who owns the shares of the LLC, right? And so if the shares are owned by a person and that person dies, the shares are worth money, but they have to be probated, right?
They have to probate the shares.
Well, you have to probate any property worth more than, I think it's $167,000. Well, I should say any property to be probated. There's a streamlined probate below 167, which is really an affidavit. You file it with the court and it takes 30, 45 days. Anything over that amount, most commonly any property in California, certainly any residence, needs to be probated. And so whether it be personal property, furniture, trading cards, guns, cars, once you have that dollar amount, you can't just change title. You have to have the court approve the process to change title. And so if you have an LLC and the shares are owned by Bob and Bob dies, well, who gets Bob's shares? Unless there's some partnership agreement or something else, Bob owns the stock, Bob's gone. Does it go to, and if Bob's married, of course, it goes to his wife. If Bob isn't married, it might go to his heirs, but you have to go to probate to make that happen. So definitely, if you own property, an LLC, it will not protect you. Well, again, talk to an attorney, but my understanding, talking to him, is the LLC, somebody has to own the shares of the LLC at the end of the day.
Right. And there's a way to make that happen by putting in more people before you pass away, like whoever the heirs are. And that also keeps the property taxes the same in California.
Can. Now that's an interesting point, because theoretically, if the state knows the property transferred within the title, within the trust, for example, it's subject to reassessment. It doesn't happen because people don't know about it.
But the title didn't change, only the partnerships.
But the ownership changed underlying it. Again, I believe the law is, if the state discovers it, they're going to charge it if it's 50% or more. And a classic case that doesn't is private country clubs, like the Brentwood Country Club. You buy membership, and because when somebody passes, it's like less than 1%, so they never get to the 50% threshold. But I believe when you're talking about LLCs, anytime a trust, anytime the asset changes, the successor trustee transfers the title from the trust to a person, most commonly. Now you can set up with multiple trusts, it's transferred within, they don't record it, but all those things are subject to litigation. I put in the link, there's no discount code, you just click on the link. I think that's all you should need.
Great, thanks.
Oh, thank you for answering that.
I have a question.
Yes, please.
Years ago, I was looking at doing stuff with probates and didn't really, I followed up some, but not much. But I was told at that point that there could be several overbids. So you could come in with that $500 cashier's check that would be over the court approved price. And somebody could come in and have a $600 check and you'd lose it. Is that true?
Yeah. So it's you have to bid more than the original buyer by 5% plus $500. So to use the example of $1 million property, if you want to overbid, you'd have to bid $1,050,500 to be over them by 5% plus $500. And I've been in cases where we had 25 different people who came in. So what happens is the listing agent and or the attorney and or the one of the heirs thinks they're so smart, they're going to hide the property. But word gets out. And so they're going to sell it to their friend. They're going to sell it to whatever. And not put in the MLS and not allow anybody to inspect it and try to do what they can to hide the property. But there are people like me who I make a living looking at those properties and looking for those hidden properties. And so there are cases I've seen where there have been 20, 25. I've been one, I think 24 was the most. So I try to assess the property, and I think part of my job is looking at the property and understanding what's the likelihood of there being bids on that particular property. But yeah, it's a challenge. I say you'll win. My record is about 1 in 3 of when we actually bid at that price and we'll win the property, or I'll prep them. You have to bid more and we'll win the property. Overall, the numbers are probably about 1 in 10, 1 in 12.
That they win on the original bid?
If you just randomly go down the list and go and bid on property, you're going to win about 1 in 12. Because
Oh,
a lot of them aren't even going to go to sale. I read the file and know that, hey, that one's not really going to happen tomorrow. Or I've talked to the attorney, I know the story on that one. Or I know the attorney, I know the agent, what's going on. So the goal, you don't want to put a check together and go downtown, I don't know, maybe you don't mind 12 times to win one. But I try to get it down to where you don't have to go 3 times to win one.
But a lot of them, if it doesn't have to go through probate or doesn't have to go through court, then it doesn't matter, does it? There's not an overbid. There's
Correct. I'm just talking about of those that go to overbid. I'm just talking about of those that do need overbidding. There's in LA County, we have about 60 a month that go to overbid. We have about another 500 that don't.
Okay.
But there's enough of the 50 for me to make a living, chasing after them.
And then you also said you were working with people in Las Vegas, and you're also looking around the US for other people, agents who are interested in working with probate. Are there a lot of different rules in each state?
Yeah. So the laws are different in each state, and then the procedures are different county to county. So because I'm kind of a unique opportunity, I've been in this business since 1986. I happen to have stumbled into the one company that's actually one company nationwide. And we have the tools to really collaborate at a deep level. And so I'm building out a nationwide network of agents in probate to kind of work together, share best practices and such. So we just opened in Georgia, and we're in negotiation right now in Florida and New York. I hope to get those done here this month of February. In Las Vegas, I'm looking for a partner. And so for me, I'm looking for in each county a real estate partner and an investor partner, and I will coach them up together how to work together, because I think it's important to have both an investor approach and a realtor approach to the same transactions. And so, definitely very active in Vegas. I know a lot of people there. And then a lot of the LA, I would say a lot, but it's not uncommon. Let me back up. It happens from time to time that there's a property, a probate in LA where the person owned a second home in Vegas. So I want to be able to service my customers in both those locations.
So do you personally need to learn what the rules are in each of the counties? Or do you leave that up to the person that says they want to come in and work with you? How do you?
Yeah, so I think part of my role is understanding there's certain basic fundamentals in all areas. They may have a slightly different name or process. The populations are different. One reason why we have so much probate in LA is probate skews where you have more poverty, right? LA has the highest poverty rate of any state in the country, county in the country. And we're a big city, we have a lot of impoverished people. So people who don't spend $5 or $7 to avoid probate end up in probate court for about 80% of it. So you can just do the math. Where are the other big, large cities love, poor people? Atlanta's another one. Las Vegas is another one. So where there are those common denominators, you have a lot of probate activity. So in those areas, there's certain principles that are similar, but I also am creating a network of attorneys. So I have on my Probate Weekly show, I invite out-of-state attorneys, out-of-state to me, to come on and interview. So I've had attorneys from New York, Florida, Georgia, Arizona scheduled in 2 weeks. So I meet attorneys, create a network. So when somebody has a question, I can contact that attorney right away, get the question answered. Usually, they're friends of mine at that point. I've helped them, and maybe get a good realtor who's in that area. If they're not yet on my team, at least an agent who's working with an attorney to get the job done properly.
So the attorneys you're looking for, are they, do they specialize in trust, or is that the best kind of attorney for you?
Well, I think I have two types of attorneys, those that avoid probate and those that live in probate. So either you're an estate planning attorney, help them avoid probate, or you're a probate administrator or probate litigator where you live in probate regularly. And I also work with a service, so that I would say for about 80% of the cases, you don't even need an attorney. There's an attorney service I recommend, easy-probate.com, where it's really kind of a self-help process, where the customer goes online with a credit card, gets started for a couple $100, and can get the basic filings done. Or they have an attorney option. And then oftentimes I'll help the customer through that process. They need somebody to answer some basic questions, which I can't give legal advice, but I can direct them to resources to get those questions answered. So sometimes it's attorney, sometimes it's an attorney service. Also, I have a company where we advance families that need money for legal fees or fixing a house up, securing it, keeping the mortgage out of foreclosure. So we'll advance $10,000, $20,000 to help them keep the property.
Do they come to you, or do you find them and talk to them about that?
At this stage of my career, most business comes to me. I'm online and I do these talks. This is my second today. I get invited to speak, a couple times a week. I have my own programs a couple times a week and a YouTube channel. And so I get people, call me, every day, 3, 4, 5 people. We have appointments. We talk about what the problem is. And sometimes I'd say 90% of the time I can just give them a game plan to solve the problem on their own. Sometimes they require either us to advance some money or somebody to advance some money, or they need somebody to help sell the property, or they need a referral to an attorney. So I help with all those.
That's great. Thank you.
Hey,
Anybody?
Bill, I have
Yeah.
a question, Peggy.
Yes,
Hey.
and then
Hey, Bill.
Nika.
Hey, question about the keeping property out of probate. If someone has written their property into trust, and then that trust is never, I guess, recorded or whatever, or the property is never recorded officially
Right.
into the name with the county in the name of the trust.
Right.
How does that affect probate? And as an addition, if the property was recorded into the trust, and then maybe they refinanced, they had to take it out of the trust in order to do the refi. Talk about that a bit.
Thank you. Yeah. So those happen all the time. So there's a statistic I've heard that 80% of trusts are never funded, meaning somebody went to the trouble to design the trust. They thought they had enough assets that needed to be in a trust, most commonly real estate. So think of a trust as like a safe deposit box. It only is effective if you put your valuables in the box and lock it, right? You can buy a great safe, let's say for your diamond jewelry, but if you leave your diamonds on the coffee table, what good is it? The thieves can come in and steal your jewelry. So the trust really works, but you have to, as Mr. Kate said, put the property in the trust. You have to deed it in the trust. And then if you take it out, same scenario. If you take your diamond necklace out of the trust and stick it on the coffee table, or out of the safe deposit box, and you forget to put it back in, you're vulnerable. It happens all the time. I don't know the number of it, but I think there's more of these cases than there are probate cases. And so there's a process, there's a famous court case, Hegstead, where Mr. and Mrs. Hegstead did this. They had a trust, but the property wasn't. But the court was convinced, based on the evidence, that it was his clear intention. I don't know the exact legal standard, to put it in the trust. And so there's a process by which you follow this motion, and then the court, if there's objections, they'll hear the objections, have a trial. If there's no objections, if you meet the standard, they'll put the property in the trust and actually deed it in the trust for the estate. So again, that's a specialized process, and I have attorneys in services that do that for me and my clients. But not uncommon at all, very common.
So in other words, if the property is either never, fully vested in the trust, it's written into a trust, but the trust isn't, the deed's not recorded, or it's taken out, it is subject to probate.
Well, the matter is a petition that's filed, and in California, that matter is heard in probate court. It could be a civil matter in other states, but it's handled in probate court in California. So yeah, to my way of thinking, it's a probate. But again, to my mind, probate's more than just specifically probate cases. It really deals with the entire genre of succession of property where the documentation isn't lined up properly ahead of time. And I'll give you another thing is, it sounds simple, right? Mom and dad had the property in a trust. And the trust said, son is bad, daughter's good. We want to give all of our assets to daughter upon our passing. Then mom and dad refinanced, deeded out of the trust, forget to put it back in the trust. So the good daughter says, well, they intended to give it to me, so let's move back in the trust and get it all. But the bad son says, oh no, 2 years before mom died, she told me she regretted treating me poorly, really wanted me to have all of it, half of it. That's why they took it out of the trust. So it's not, everything is simple until it's not. And I would say that these are cases, they end up being litigated in probate court. What was their intention and what documents do you have to prove it? And I've seen all kinds of stories in that area.
And last thing, Bill, businesses are if someone owns a business or, LLC or something like that, single member, or they're self-employed and they have some kind of business corporation or any other kind of formation, is that also something that needs to be considered in terms of estate planning so that it does not fall under the probate issue?
Well, estate planning also could include limiting taxable, taxation. So yeah, probably it all has to be reviewed by a proper estate planning, attorney or accountant. But probate is limited to the estate's value being more than the threshold of $167,000. So it could be baseball cards, it could be firearms I've seen, it could be cars, it could be an LLC, it could be a business, it could be personal property, antique furniture, it could be anything. It doesn't have to be real estate property. So it could be anything that the estate owns. The exceptions would be depository accounts with a named beneficiary. So most commonly, you open a securities account at Vanguard or TD Ameritrade, and they'll ask you, well, upon your passing, who does this go to? And you put your name, your daughter, your spouse, whatever. That transfers without probate. And life insurance, if you have a named beneficiary, then it would go to the named beneficiary. So those are two examples of things that avoid probate. But everything else that's in the estate, all the property of the estate. I'll give you another example. It happened to me personally. My aunt had a trust. She also had a checking account for more of the regular month-to-month kind of money, and it had like $50,000 in it. And she, my sister was the trustee of the trust, and she had my sister on the account as a power of attorney, under thinking that if ever need be, my sister could step in and write a check and transfer the funds. Well, it sounds good, but power of attorney extinguishes with the decedent, meaning when she died, the power of attorney no longer was effective. Of course, but Wells Fargo loves that because they make you dance through all kinds of hoops and pay fees to transfer the money to a trust account. So power of attorney really won't get you through the process either, most commonly. But all these are great legal questions that you should, if appropriate for you personally, talk to an attorney. I'm giving you more my business strategy perspective on all this.
Nika?
So do you have to worry about a redemption period if you buy things at an auction for someone to come back? Is there like a year long or?
Yeah, as far as my knowledge, again, I'm not an attorney, but I do know that when we buy property at probate court, we buy property avoiding probate court because it's full authority, you're getting a full title insurance policy giving you clear title. Unlike when you buy a trustee sale property at a trustee auction, like at the court, most commonly, or unlike a sheriff's sale where you're buying it from the sheriff, that's an auction also. you're not getting clear title insurance. You're getting just a deed. So probate court sales and probate sales not going to probate court, the buyer gets a regular title insurance policy with clear title on it. Now, the challenge there is, I'll just share with you, it's not uncommon for probates to include other forms of litigation. For example, I had a listing a few years ago where a woman had a wife and they're married legally and then legally divorced, whatever that means. And, but legally divorced, so they had no legal relationship. The woman owned a house, and in her later years, as she got sick, she and her ex-wife reacquainted, reinitiated a relationship. And so the ex-wife moved in the house to live there, to take care of the animals and take care of her and such. Very nice story. So when she passes, the ex-wife has no legal standing.
And deep breath.
But she lived in the house. She claimed that her ex-wife had told her she deeded the property. And it allowed her to live there for a while until we got, filed the lawsuit and eviction and such. So what happens is, even though we legally had her removed and then legally went to seek the property, the title company, if she had reinitiated more litigation, won't issue clear title insurance. As long as there's open litigation, the title companies aren't obligated to issue title insurance. They don't want to get involved in any kind of litigation. So to answer your question, there's no real redemption period. The title company is going to make sure there's no legal issues because they are issuing you a clear title policy on a probate sale.
So you brought up title, and one of the things I noticed that most attorneys don't do when they fund the, let's say, the real estate, the single family home into the trust, is they do not have the title insurance put in place. So now you don't have a, what's it called when the title, the stream, not the stream, that's not what
Chain
it's
of title.
Say again?
Chain of title.
Chain, yeah, so the chain's broken.
Yep.
And I don't know, why don't attorneys, I mean, here they are supposedly protecting you, and then that didn't protect you. Do they just not think about it? Is it not on their checklist? Do they not know about title insurance?
I think they don't think about it. And I think also, if you go to most customers and say, well, look, on the off chance that you'll need this chain insured, you can pay for title insurance now, or you can wait until you sell the property and then do the research. And most people say, no, I'm not going to spend a couple $1,000s now, I'll wait till later. People don't necessarily appreciate the value of that. I have a case right now where my client bought a property in LLC. He transferred it to another LLC, sold it to somebody. But the original LLC, not his, didn't file taxes and became, what's the word? Discontinued. There's a word for it, legal word for it in California. So now we're going to sell this property and we can't get title insurance, so we have to go back to inactive. We go back and reactivate this corporation, which means filing 2 years tax returns by $800 a piece, plus accounting fees, plus just getting the owner to agree to do it and sign the paperwork. Not so simple. So definitely because there's no title insurance when the corporations sold from one to the other, they didn't do title insurance.
So
Very common.
my mom had a trust, and the attorney didn't file the title insurance and didn't advise my mother to do that, but they only charge like $50 to do that. Wasn't any big deal. That's what they said. It's no big deal, $50 for us to do the paperwork.
Okay.
So
I mean,
that-
as long as the person's around to sign it, it's not a big deal. When the person's not around to sign it is when it becomes a problem.
Yeah, she wasn't around to sign it, and they still did that
Hmm.
because we had all the documentation.
Well, probably they just put it in the trust. They didn't, or put
That's
it in
all they did.
Yeah,
They
that's
put it-
different. Recording a document costs nothing. Getting a defunct corporation reactivated is a different story, or getting
Yes.
a different
That-
party. Yeah. And look, sometimes you have a classic case. Classic is, married husband, wife, get divorced. One keeps the property, one signs a quitclaim deed. They sign it, but they don't get it insured at that time. 5 years pass, 10 years pass. The other spouse, the husband or the wife, wants to sell the house now. Say, well, your spouse is on here. Oh, I have a quitclaim deed. That wasn't insured. And they'll make you go back and get the ex-spouse to prove up that she signed it or verify with an affidavit or something. Well, you can imagine that could be a nightmare. Now, the attorneys will write an agreement that they agree to, correct any defects, but signing that, getting your ex-spouse to sign that can be two different things. I've seen it.
I'm sure you have. I've seen it all. Marcy, do you have a question? Okay. Anyone else have a question? So most of you haven't experienced this unless you have parents that have passed or relatives that have passed, or you're an executive. Is there anybody here who's an executive on a trust? No, well, so there's an executive and then there's a trustee, and those are two different parties to the trust, as I recall. And in probate, there's the will, right? So there's the executor of the will.
So you have the person representative files the case. If there's a will, then they're the executor of the will. If there's no will, then they're fine to be the administrator of the estate.
Oh, how often does that happen when there's no will?
A lot. Or there's a will, but it's no good. It's not done properly. Yeah, a lot.
Really? Okay, so do we need to get more education out there?
Well, I do think that particularly in lower income, if you own a house, you should have a living trust. It's just, like I said, I talk to attorneys, and there's the occasional guy who will say, "Oh no, most living trusts aren't any good." You get in line. Most attorneys will agree with me. 90% of the time, you're better off with when you get online, and you should update every 5 years than nothing, and then make sure you deed your property into the trust. Very important.
Thank you. And Cliff?
Sorry, I was taking notes. So did I hear you make a comment earlier that some of the strategies that you see some of your clients make in moving their properties or deeding their properties into a trust or an LLC, some actually don't trigger a reappraisal? And if that's it, which ones are most successful?
Oh, I'll say they all trigger the county saying they're going to reappraise. There's a form you fill out that you file with LA County. I'm sure it's different in every state. There's a form that should be filed when you file the deed that says this should not be reappraised, and here's the reason why. And it's done for trust, or there's certain family relationships that should avoid it. So if you fill out the form properly, but people don't think about that at the time. And then, I don't know why, but half the time I think the county just sends a letter out saying we're going to reassess anyhow. And then you have to, again, file the paperwork and do all that. So, but there is a form to file with in each county, LA County for sure. To
When you file that form properly and it's moved into the trust, then they don't come out and reappraise.
reassess.
Or assess, rather.
Reassess
sorry.
for tax purposes. Yeah,
Okay.
theoretically, yes. I mean, the idea is there's certain transactions that should not trigger a reassessment. Putting a property in a trust should not trigger a reassessment. Inter-spouse should not trigger a reassessment. Parent to child should not trigger a reassessment. So you have to document that. That's the case. You're saying basically an affidavit. And but does the county sometimes get the form and not read it properly? Of course. County government,
Is there something that we should do on our side to ensure that that is received and processed correctly?
I don't think there's anything you can do to avoid it. I think you just have to pay attention to it, watch for it. I think, I'd like to say yes. I would like to think that if you took the form into the county and handed it to them, but they won't process it on the spot for you. So
Okay.
I don't think there's anything you really can do other than watch for it and watch your property tax bill the first time and make sure if it's reassessed, jump on it right away. And it's not complicated. It's a simple form. It's in English. Some people like an attorney to help them with that and pay the fee to do that. If you're talking about a lot of money, it's probably worth paying an attorney to do it for you if that's what you think you need. I don't begrudge an attorney. Look, they might charge $400 an hour to fill out a form you could do on your own. But if you pay an hour, $400, and it's done right, and you avoid a $10,000 reassessment annually, maybe it's worth it to you. I don't want to judge. I'm just saying take appropriate action.
Thanks.
Thank you. Anything else? Any other questions? Well, thank you very much, Bill, very much for doing this. We really appreciate it. And I hope everyone got something out of this that they could put to use.
Thank you. I put my contact info in the chat box. I host a program, probateweekly.com, on Thursdays at 4. And I have a YouTube channel, youtube.com/. billgrossexp, which is the company I'm affiliated with. So I can
And
ever
would
help you guys.
And would you put that video link in there also from
It is.
some auction? Okay, thank you.
Yeah. Thank you. Thank you, everybody.